Okay, good morning, ladies and gentlemen.
Good morning, John.
Happy to see you again, and also to see our speakers online already in good shape. And it's a pleasure to welcome you to the second day of our conference. Yesterday we had some excellent discussions, I thought, on a range of issues relating to secondary sanctions, including the question of the jurisdictional aspects, as well as the very concept itself and the impact that secondary sanctions cause on trade and finance, but also in humanitarian terms. And I'm more than happy to continue our second day. We have again a busy schedule ahead of us with 3 panels that will in turn focus on questions of international economic law, and then on the impact of secondary sanctions in the context of domestic litigation. And as we've announced and as we've seen on the program, with a more forward-looking panel that also looks at how states, including the European Union, seek to respond to secondary sanctions. But let's start with first things first. I'm very happy to introduce our speakers. We have a panel of 4 experts that will tackle various dimensions of international economic law. I will introduce them each in turn and invite them to take the floor for between 15 and 20 minutes, more or less. We will first have all of the presentations back to back and end this session with a Q&A with the audience, both here at the conference venue and of course our audience joining us online. Good. Our first speaker will be Professor Dr. Anna Maria Viterbo, who is a associate professor of international law at the Department of Law at the University of Torino and a law fellow at the Collegio Carlo Alberto. She was formerly a member of the Italian bar and obtained a PhD from Bocconi University in Milan. Anna Maria is one of the few persons, to my knowledge, to have written extensively on the interaction between secondary sanctions and monetary law, and I've personally learned quite a bit from her writings, and I'm very happy she's here with us today. So the floor is yours.
Thank you, Tom. Thank you all for your kind invitation. I'm so sorry I was unable to join you in Ghent, but you know the pandemic is kicking back again, unfortunately. So let me share the screen with you, my presentation. And let me start my presentation by clarifying 2 points. The first is related to the definitional schism highlighted yesterday by Charlotte Bossillon. For the purpose of analyzing sanctions under a monetary law perspective, I consider, in fact, more appropriate to focus on extraterritorial sanctions than on only secondary ones. This is so because asset freeze, which is the most interesting type of sanction from an international monetary law standpoint, is a measure that applies to blacklisted entities irrespective of the fact that their designation results from primary sanctions with an extraterritorial reach or from secondary sanctions. As we all know, primary sanction private individuals and companies under the sanctioning state's jurisdiction from carrying out business with a targeted country, and under certain circumstances, they may have an extraterritorial reach. For instance, when they are addressed to non-US persons which are cause US person to infringe sanctions. On the other hand, secondary sanctions apply to foreign persons and activities taking place entirely outside the jurisdiction of the United States, and they trigger a number of measures, among which the blocking of property and interest in property. So therefore, while secondary sanctions are always extraterritorial, extraterritorial sanctions are not only secondary. My second preliminary point, I would like to draw your attention to the fact that asset freeze and the blocking of property apply to a wide range of financial assets and interests of every kind, including but not limited to bank deposits, saving accounts, cash checks, debts and debt obligations, securities, interest, dividends, and you name it. These measures entail restrictions on both transboundary payments and international capital movements. So having set the stage, I can now move to my international monetary law analysis. But from the point of view of customary international law, something that was already mentioned yesterday, reference has to be made to the principle of monetary sovereignty, distinguishing between its internal and external character. Internal monetary sovereignty includes the right to issue the currency, to designate legal tender, to operate on monetary policy. External monetary sovereignty includes the right to impose payment restrictions and capital controls, as well as sanctions like blocking or freezing measures. The exercise of external monetary sovereignty has obviously a great impact upon other states and their nationals. However, under customary international law, this does not entitle a state to exercise control over transactions which, yes, involve its currency, but occur abroad and are governed by foreign law. This is so even if the transaction, in my opinion, are clear through its financial institutions. Then if we talk about the nexus, the fact that a US financial institution is involved, then we are talking about another aspect of this kind of measures. If we move to treaty law, and in particular IMF law, it is worth recalling that the IMF Articles of Agreement provide for an asymmetric treatment of current and capital transactions. So on the one hand, members of the IMF enjoy ample freedom to control capital movements. And on the other, they are prohibited from imposing payments restrictions, better in the language of the IMF, exchange restrictions, and this without the fund's approval. So since the IMF articles do not establish criteria for the fund's approval of exchange restrictions, and I'm now focusing on current transactions, the matter is left to the determination of the IMF Executive Board. And perhaps surprisingly, with all the changes that have occurred in the global economy since the IMF Articles of Agreement were drafted in Bretton Woods, the policies that were adopted at the very beginning, in the end of the 40s, beginning of the 50s, by the IMF Executive Board, still instruct the fund on the matter nowadays. So as a general principle, in the view of according to the decisions adopted by the Executive Board, exchange restrictions can be approved by the IMF only when they are introduced for balance of payment reasons, and in that case, if they are both non-discriminatory and temporary. All other restrictions, in principle, should be avoided to the greatest possible extent. However, under US pressure, the issue of security restriction, those introduced to preserve national or international security, assume center stage already in the first years of the fund activity. When in 1951, the United States imposed restriction on China and North Korea, they made it clear that the US expected the fund not to take steps against such measures. The issue was debated before the Executive Board and led to a decision that is still applicable today, decision number 144 of 1952, that while acknowledging that the fund is not a suitable forum for the discussion of political and military consideration that can lead to action of this kind, to the introduction of exchange restrictions, the decision nonetheless established a very particular kind of procedure, a simplified procedure for the approval of such restrictions. And sorry, it doesn't move. Yes, sorry for this. And it established a tacit approval procedure for security restriction that only have to be notified to the IMF Executive Board, if possible, in advance of applying such a decision. And if the fund does not reply within 30 days, then the imposing member may assume that the fund has no objection to the introduction of such restrictions. Maybe at the time, the centrality of this issue of security restriction was not entirely appreciated, because the target of these of the US measures were China and North Korea at that time were not yet member of the fund. So there might be, they might have been not consider at which point this decision would have influenced the behavior of members in the future. So to our knowledge, since then, the fund has never objected to restrictions introduced for on the basis of security grounds. Not even discussing the issue whether they were imposed pursuant to a UN Security Council resolution or if they were of an entirely unilateral nature. So security restriction, especially those of a unilateral and extraterritorial nature, raise several issues. First, they are not justified by a balance of payment need. They are often of a discriminatory nature, and they can be retained indefinitely. So the complete opposite of the exchange restrictions that can be approved by the fund for balance of payments. Second, the IMF passive attitude towards unilateral security restrictions can be considered inconsistent with the IMF obligations as a UN specialized agency. I put a question mark because the agreement between the UN and the IMF, the relationship agreement, recognized the fund such a strong independence from the United Nations that the fund is only required to have due regard to the decision of the UN Security Council. So the question is open. Third, decision number 144 on security restriction was adopted 70 years ago, and the same decision provides that the fund will have to review its operation periodically, but such review has never been undertaken, despite some discussion about this in the mid of 88 within the executive board. And the archives and the minutes are very interesting material to study. Last but not least, it is the view of the fund that security restrictions automatically benefit from the extraterritorial protection of IMF Article 8, Section 2b. So this question merits careful consideration. As a rule, states, we said it already, are free to give or to deny legal effect to exchange control regulations of other countries. Well, IMF Article 8, Section 2b is an exception to this customary rule, and it establishes whether and to what extent IMF members have to recognize an exchange control regulation which another member had introduced in compliance with the IMF articles. In compliance with the articles means that, therefore, the notion of exchange control regulations includes both exchange restrictions, which are tacitly or explicitly approved by the IMF, but also includes capital controls, because they are introduced in compliance with the IMF articles under Article 6, Section 3 of the IMF statute. The countries are authorized to introduce capital controls. These implies that the effectiveness and reach of sanctions regimes could be significantly boosted by the special status they are granted by Article 8, Section 2b. This is quite a complex issue. I will refer it in more detail in my paper because I'm not in time to deal in the intricacies of the terminology used by this provision. But it is my conclusion that the IMF framework should be reviewed and updated. In the first place, the IMF could benefit from distinguishing more thoroughly between multilateral and unilateral sanctions, especially those which an extraterritorial character. To this end, Executive Board Decision 144 should be amended to remove the tacit approval procedure as already advocated by some experts back in the 80s, and to exclude unilateral sanctions from its scope of applications. In addition, a new authoritative interpretation of Article 8, Section 2b could be adopted to exclude security restrictions from its scope of application. Here, it is worth recalling that the procedure to adopt authoritative interpretations set by IMF Article 29 represents the only exception to the IMF weighted voting system at the end of the procedure. I have to be clear on that. And despite not having been applied since the end of the 50s, it might be reactivated to increase the chances of reaching consensus on such sensitive issues. Thank you for your attention.
Thank you very much, Anna Maria, for enlightening us and explaining the IMF approach and drawing our attention to the 1952 decision. I would now pass the floor. Apologies. So I would now like to turn the floor to our second speaker. Our second speaker is Professor Dr. Peter Tobias Stoll. Professor Stoll holds the Jean Monnet Chair for the European Union and Global Sustainable Development through Law. And he is a professor for public and public international law at the University of Göttingen. He is a director of the Institute for International Law and European Law, where he has the Department for International Economic and Environmental Law. Professor Stoll, the floor is yours. Thank you.
Thank you very much, anybody, and thank you for. I'm sorry. And thank you for inviting me, first of all, and congratulations to the organizers of this conference to address such a timely and highly relevant issue, which is secondary sanctions. And also, I'm very sorry not to have been able to make it for Ghent. You know that the restrictions apply, and very sadly, we now have to have our wonderful conferences in an online mode, and I feel very sorry for that. I hope that we will have later a chance to meet in person again. But let me now turn to my task, which is to briefly introduce you to secondary sanctions in the perspective of WTO law. And first of all, thank you for giving me this topic, because I learned so much about the WTO in preparing for this wonderful conference. Because sometimes we really think that the WTO would be something like a Magna Carta for economic activities and relations around the world. At least the WTO is portrayed to be something like this. And I have to say that when looking more precisely into its rules and commitments under the WTO, also in view of associated trade agreements that we see in great number, even mushrooming around, we will find that this international trade system actually only addresses very specific issues. And looking at it from the side of sanctions is especially telling, because there we see that it hardly protects individuals or companies, but what it does is to define certain levels of liberalization of certain types of transactions only. And therefore, to look whether a certain specific sanctions would affect rules and commitments under the WTO or related trade agreements would have to be done on a case-by-case study. And I'm almost sure that the people who design sanction measures have a close look to the WTO commitments of their related countries to figure out what they can do or what perhaps they should not do in this regard. But more generally, we could say that the situation is quite clear if we look to the trade in goods. There we would see that a number of potential sanctions would be, first of all, and more generally be prohibited, and I'm coming to the exemption clause in due course, but in principle, any kind of import or export bans, and it is important that I highlight that it is also covering export bans, directed against whole countries or also directed against individual companies, would in principle conflict with obligations and commitments under the WTO. And the same would be true for tariff increases if you have something like a punishing tariff. Also, it should be noted, because there's a new tendency not to take measures at the border in a way which are operated by customs officers or something, but to require importers or business operators within a market to buy or not to buy certain foreign goods. And that would also be covered in principle as far as the sanctioning state is exercising a direction in this regard. So for instance, if a sanctioning country would come up with a measure disallowing certain business operators and importers in its own country and in its own market, disallowing them to buy certain foreign goods and to import them, that would also come into conflict with certain WTO rules, be it, first of all, Article 11 of the Ghent Agreement, or be it Article 3, Para 4 of the Ghent Agreement. So, first of all, the prohibition of quantitative restrictions, and secondly, the national treatment provision. Also, of course, in any of those cases, we would also see a violation of the most favored nations principle. And the recent case, one of our key cases that I will discuss in a minute, which is the Russia transit case, also showed us that also there's an obligation in the Ghent agreement to offer free transit, and that is another obligation which might come into play if we think about trade in goods. With trade in services, we are a bit more close to the typical modern economic sanctions or smart sanctions, which would address particular companies, would freeze assets, would disallow visa, and so on and so on. But the area of trade and services is very complicated because most of its obligations and commitments are only in force if the country at hand did actually take a commitment in this particular areas and has offered market access and national treatment. Where we have those commitments, of course, any restriction to the provision or also to the consumption of services would in principle violate commitments under the Ghent agreement. And in conjunction with market access in this area, we often see further commitments regarding to several of the modes in which you can provide a service in view of trade and services. And those modes, like you know, will cover the presence of natural persons, the operation of a commercial representation, and also payment and capital transfers. So this will all be covered if it takes place in the context of a trade and service transaction for which the country which takes the sanction has taken over certain commitments. I think this explains very well why the WTO is not a sort of a Magna Carta which covers economic activities and more specifically also the interests and rights of economic operators around the world, but rather it is only a rule book for very specific types of trade transactions. And that is why in each and any case, we have to look very specifically whether there could be a violation of any of the rules and commitments under the WTO. And the same would also hold true for free trade agreements. But of course, a violation of the more general commitments and obligations under international trade law, and particularly the WTO, is not the last word. As you know, in many instances, international trade law has a rule and exception kind of a structure, and the very much discussed and notable exception which we have at hand here is, of course, the security exemption, national security exemption in, and I take this as an example here, in Article 21 of the Ghent agreement. And first of all, let me explain to you that I will not look into questions of reviewability, because those are particularly treated by Geraldo Vidigal, as I understand from the program. So I'm only looking into the more substantial questions arising from Article 21 of the Ghent agreement. And I think most of you are well aware of this provision because it has lately been discussed very much, not least because of the panel decision in Russia transit, which is remarkable in many aspects and has given us good food for thought in various aspects concerning the law of international trade and particularly of the WTO. And as you will be well aware, Article 21 has a specific part which is under litera B, which would basically say that nothing in the agreement, and that is the exemptionary power vested in this article, would prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests. And as you might be well aware, because of this wording consider, the reviewability and also the reviewability of the whole clause had been discussed, and also, and that is a more substantial part of it, the whole clause has been considered to be self-judging. That is an argument which has been put forward by Russia in the Russia transit case, but it has on occasion also brought forward by the US, for instance, in a couple of other cases. Before really delving into Russia transit and the interpretation of Article 21, I first of all have to state that Russia transit was about a primary sanction case. And let me tell you also that there are a number of primary sanctions having taken place in the area of international trade law before, much more cases than we would think of. But I understand that here primary sanctions are not so much the problem, but just for you to let you know. But this exemptionary authority given to member states to restrict or to violate certain general rules of the GATT and to be justified for this, of course, comes along with a number of conditions, and you will be well aware of them. Article 21 litera B only applies in a few more specific cases, which is fissionable materials and materials from which they are derived, then traffic in arms, ammunition, and so on, and the purpose of supplying a military establishment. And we are most interested in sub-condition 3, which is taken in time of war or other emergency in international relations, because that will be the most applicable condition in our cases of secondary sanctions. So how now can we understand the current state of interpretation of Article 21 in this context? Under Russia transit, which has really been a very thoughtful panel decision explaining very clearly what the provision is all about, particularly several elements of Article 21 litera B have been qualified in view of the question whether they are self-judging or not, or to which extent they would be self-judging or not. And the first good news is that the panel thought that the conditions 1 to 3 to Article 21 litera B would be objective facts that the panel could well consider in its own merit, and that no kind of self-judging would apply in this area. And that is quite important. So something like an objective determination takes place in this regard. And that is also, and interestingly, also true for the wording emergency in international relations, which from first reading, many of us would consider to be a typical kind of a self-judging element. However, the panel considered that also the time of war or other emergency in international relations is open to an objective determination. And this kind of an objective determination surely would have to take into consideration that the state at hand or the WTO member at hand has a certain discretionary power in defining itself what it considers an emergency in international relations. But in the end, it is an objective determination, and an assessment can be made and should be made in this point. But then, of course, the panel, in a way, consequentially looked also at the chapeau sentence of Article 21, litera B. And of course, it took regard to the fact that there we find this word considered to, which is normally considered to be a main element of a self-judging clause. And indeed, the panel said, well, in principle, the chapeau of Article 21, litera B is self-judging, but it should be noted that the panel added something, which is that nevertheless, it can be, when using this self-judging power under the chapeau sentence of litera B of Article 21, you should not forget to apply bona fide, which is kind of a very principled element of each legal order. So they were basically saying, okay, here in this regard, WTO members have a self-judging power, but this is not without any limits, but the limits are given by more general principles of law, which is, for instance, bona fide. And so, for instance, one element in the chapeau clause, which is essential security interests, according to the panel, must be articulated sufficiently enough to demonstrate its relevance or veracity. So that is a point which is very interesting and which I will use in a second, which shows kind of a very typical public law type of an argument to say, well, a certain addressee of a norm has a discretion how to determine a certain condition, but nevertheless, it must be articulated and, should I say, reasoned to some extent to allow other addressees of that norm to figure out whether that is kind of a reasonable conduct. But this essential security interest is only one element which we find in the chapeau clause. The other one is the measures necessary to protect those essential security interests. And I think it is quite clear that there should be a connection between the measure and the security interest. And although this connection between the measure and the security interest is considered also to be covered by the self-judging function of this chapeau sentence, nevertheless, the panel asked already there for a minimum requirement of plausibility. So the question is, how do we, in a way, how do we define the necessity standard? And in this regard, I should say, of course, that Anna Maria and that you, Tom, together with Cedric, you have had whole articles on this matter. And I can basically subscribe to what you argued. First of all, it should be noted that this necessity, in a way, cannot be, in an oversimplification, be considered to foreclose any secondary sanctions at all. I think in properly interpreting the necessity element, we cannot draw kind of a borderline between primary sanctions and secondary sanctions in general. And I think most of you agree to that, and I think that is true. Rather, we have to look into the link between the essential security interest and the necessity in a more subtle way. And there I found it quite conclusive what has been offered to think about something like responsibility, and particularly Tom and Cedric, you have made the argument with the state responsibility draft articles and the issue of countermeasures, which of course is not even in the draft articles a matter which is totally clear, but nevertheless, this idea that you are affected by sanctions to which you are not linked in a way that the original reason and all the circumstances which led to the sanctions have to do anything with you, is, I think, in a way very conclusive. And I would suggest that we take the bona fide argument of Russia transit one step further in arguing that also the bona fide argument should in a way guide the assessment of whether necessity can be proven, in particular in the case of secondary sanctions. And I would do so on a larger and more principled kind of an argument. I would basically say that at large, the WTO system can be seen as a system of legalization of international trade transactions. And I would argue that it is the main tenet of each legal system to provide for predictability. And within such a system, I would argue, members fundamentally face the obligation to behave in a way which is foreseeable and reasonable for others in this legal system. And I would argue that in this regard, for secondary sanctions, what would be needed would be a further explanation on the necessity, which particularly takes into account this secondary nature of the sanction at hand. And I would, if I may scroll back, suggest that we take the wording from the Russia transit case, where it said that regarding essential security interests, the WTO member taking the action must articulate sufficiently enough why it is considering a certain issue as an essential security interest, that we also apply this, but separately and more specifically also to the question of secondary sanctions, and that in a way we require, as by way of interpretation of Article 21 litera B, require that in the case of secondary sanctions, the sanctioning WTO member has to specifically explain why it is taking this measure against a third state which is not affected to the original course of the sanctions. And I would argue this particularly because any kind of a legal system is about predictability and about that you can rely on kind of a reasonable and foreseeable conduct by others. I mean, that is why we have legal systems to argue this and to make it work. And in this regard, I would say there's a specific kind of you could call it responsibility if you think about the word respond, which is inherent in responsibility, that a WTO member taking such a secondary sanctions particularly explains why this has been in a way necessary, contrary to what we understand to be bona fide. And I think by qualifying this kind of a duty to explain and to give reason, we can do much in the further development of Article 21 and making it really a device working against secondary sanctions, which in my view, in the end, are particularly to be seen critically because they work against the kind of expectations that in a legal system you have predictability and that there is reason for taking certain measures. Thank you very much, and I'm looking forward very much to the discussion on this point. Thank you.
Thank you very much, Professor Stoll, for an insightful presentation. It's good to hear, of course, that we are on the same page when it comes to the necessity criteria under Article 21. And let me just say that we must hope to welcome both yourself and Professor Viterbo to Ghent in person on another occasion under better auspices. Now, the time has come to move from our two online participants to the two panelists that are present here at the conference venue. And the first of those, let me briefly introduce, is playing actually a home game. Indeed, Professor Erik de Brabandere is actually an alumnus from Ghent University, obtained his PhD degree at Ghent University and still lives close to the city in a way. That being said, he is of course better known to most of you as the chair of international dispute settlements at Leiden University Law School and as a co-founder and partner of DNB Law. And last but not the least, of course, as director of the well-known Grotius Center for International Legal Studies. He's also co-editor-in-chief of the Leiden Journal of International Law, and recently co-authored the new edition of Meijels International Dispute Settlement, an authoritative work that many of us have consulted in the past, I assume. So, Erik, the floor is yours. Thank you very much.
Very much, Tom, for your kind introduction. It's indeed a home game. It's also the advantage of not having to travel, no request travel authorization to actually speak here. So many thanks for having invited me. So the idea is to discuss secondary sanction and international investment law. I think there are many aspects that we can discuss. There are two that I will not discuss, maybe briefly hint at some issues. The first one is something that Geraldo will cover, which is basically exceptions, security exceptions, and the self-judging nature of these. The second part, which is the impact on the arbitral proceedings themselves, which is something that will be covered in the next panel under the auspices of Nicolas Angelet. Maybe I'll give some small hints at what I think are interesting thoughts, but I'll not discuss this in much detail. So secondary sanctions and international investment law is a bit of a tricky topic, to be honest. It's tricky because if I take also the presentation from yesterday, also from Charlotte Beausillon on the understandings of what are secondary sanctions, they of course mostly relate to, or there's a close link with extraterritoriality, right? So it's the idea basically that you impose sanctions on third parties. And this precisely sits at odds with international investment law, which is on the contrary predicated on the existence of a territorial link. So foreign investment, as you know, is mainly an area of law where you regulate the existence or the treatment of foreign investors that have an activity in the territory of one state. And here you directly see, I think, the tensions that can exist with the whole notion of secondary sanctions and the extraterritorial effect of sanctions is precisely that the state regulates, adopts legislation, acts that have an effect outside of the territory and basically affect investment that may exist in another state, but not necessarily or only foreign investors that have a presence in that state. Also, there are not many cases we can rely upon. There are a couple of cases which sort of explain or are relatively parallel, similar to situations we can envisage in the context of investment law, and those are the ones I will cover. Of course, that's the third element that's of course important, is that sanctions have a huge effect on investment. This is or a huge impact on investment, mostly potential future investment in another state. But the question, of course, is this impact enough to trigger the application of investment treaties, both as such, the application, and then the specific norms that relate to the treatment of foreign investors. So this is what I'll cover, or at least try to cover today. So in terms of scope of application, again, as I said, there's always the need for a territorial nexus, right? So you have an investor from one state investing in another state. Mostly these investment relations are regulated by investment treaties that are mostly bilateral in nature, less so in the past years with what we call the mega regionals, treaties signed by the EU, amongst others. Also, of course, partly by foreign, free trade agreements, which have increasingly investment chapters, but they're roughly similar to bilateral investment treaties. So the question is, first of all, do you have an investment in the territory? If we take an example of the sanctions issued by the United States, to have an investment and be an investor under a specific investment treaty, you would need to be, if I take the example, a Belgian investor who has an investment in the United States to be affected by that investment. So that's the foreign investor aspect. But secondly, and this is also important, you need, of course, to have an investment in the US, which is affected by the sanctions, right? And this is precisely, I think, where the link is not always easy, in the sense that you will not easily find situations where this actually can occur. Now, this territorial link has been slightly broadly expanded or interpreted by certain tribunals of the past. For instance, in relation to financial instruments, it has been decided that it's not only a territorial presence, but a general benefit or effect on the other territory might be sufficient. It's a famous case, FEDAX, which has decided this. Second interesting case is also Abaclat versus Argentina, bondholders, where again the question is, do you have an investment in the territory of the other state? Was interpreted relatively broadly, again with the idea that there's a general effect or benefit to the state where the investment is allegedly made. The third element, SGS versus Philippines, an interesting case where they generally consider that you need to look at investments as a whole, right? So you may have certain parts of an investment that are affected by certain acts, legislation of a certain state, which may not necessarily be in the territory, but taken as a whole can be considered as an investment in the territory of the other state. So again, irrespective of the fact that you wouldn't need an investment in the territory, there are certain ways where you can imagine that investors that are foreign, that have an investment that is affected by secondary sanctions, may nonetheless, under these grounds, be considered to have made an investment in the territory, in my example, of the United States. So this is an inherent limitation to the application of international investment law in the specific context, which is basically the situation where you have a host state that takes measures, sanctions, which negatively affect a foreign investor, but that foreign investor needs to have made an investment in the state issuing the sanctions to be able to hold that state responsible for having taken certain actions in violation of the applicable investment treaty. So it basically rules out US investors in the US, right? But it also rules out all foreign investors who simply have no investments in the US. So that's an important limitation. Now, there is one aspect where there is nonetheless a clear link, and this relates to the, when I leave a bit outside the scope of application, those treaties, there are roughly two models in terms of access of foreign investors. Right? Typically, traditionally, an investment treaty is what we call post-entry. So you're protected once you have entered the territory. You're protected under a treaty once you have made an investment. It doesn't really guarantee or give you access to the territory. Now, certain treaties in the US, Canada, Japan, amongst others, are states that have treaties that extend protection not only to the investments made, but also guarantee, or at least have certain provisions on access to the territory, admission or establishment. Admission or establishment is not only the initial, but also covers expansion of an existing investment. And I think here you might also see some interesting elements in the context of secondary sanctions. So the first sort of traditional, what they call European model, it's only post-entry, and admission is only in accordance with the law. The law can change, the law doesn't guarantee access. So in that context, admission is not guaranteed unless, of course, specific legislation applies. If you look at those other treaties, they basically do not necessarily admit or authorize establishment of foreign investors in general, what they basically do is impose non-discrimination in relation to admission and establishment. That is, there's an obligation of national treatment and most favored nation treatment, not only once you have invested, but to gain access to the territory. So basically two non-discrimination standards towards the domestic investors and towards investors of other states. This is done through various ways. Sometimes you have a positive list of sectors that are open. Sometimes you have a negative list of sectors that are closed. But the important point here is that this, in the specific context of secondary sanctions, may of course have an effect, right? If you have already an investment and you want to expand it, or there is an idea, of course, to establish or to make an investment, you can, of course, claim breaches of the treaties based on the violation of those two specific standards. So non-discrimination in relation to domestic investors, non-discrimination in relation to most favored nation. Now, this seems hypothetically interesting, yes, but there are a couple of caveats here as well. One, you have treaties that exclude such questions from investor-state arbitration. So it means that you would theoretically, hypothetically have a claim, but it will not be the subject of a claim in a direct claim from the investor against the state. The Canada-Egyptian BIT is an example that excludes this. Not all of them. The US model BIT, for instance, does not exclude access from dispute settlement. So in that case, it would be covered. These cases have been relatively, there have been relatively few cases on this. There's one recent case which I think is quite interesting. Global Telecom Holding versus Canada. It relates not to sanctions, but to a security screening, the acquisition of a company, Global Telecom Holding, in Egypt that was owned by Russians that were actually using equipment manufactured by Huawei, and they were actually banned from taking over a telecom operator in Canada. The tribunal there, in the end, established jurisdiction because, again, this was based on the Egyptian-Canadian BITs, which carved out those questions from dispute settlement. The tribunal in the end found that it was not an acquisition because it was basically based on a pre-existing agreement to transform shares, which technically would not be an acquisition under the treaty. But so you can imagine those situations to become increasingly relevant, of course, but it implies, of course, the either admission or establishment initially and a violation of those standards, leaving aside questions of security exceptions, which I leave to Geraldo to cover, which would also be applicable here. Leaving aside the sectors in which there might be exclusions, and mostly these relate to sensitive areas such as telecom, amongst others. And leaving aside also the traditional BITs, which basically do not say anything about the right to admit, the right to access to the territory. Now, if you look at the second part, which is then once you have entered, can you claim violations? Again, keep in mind the territorial nexus, which is really fundamental, which again, I think will in all likelihood be a relatively important hurdle to find violations of investment treaties for extraterritorial sanctions. I gave you one example also, a recent case that has been initiated last year, but there has not been any, the case is still pending without the tribunal yet being constituted. It's a case Huawei against Sweden that was initiated last year, basically related to the ban under Swedish regulations for those that participate in a bid for the 5G network to use Huawei material. Relatively similar, the only difference between this and probably the hypothetical situations in the context of secondary sanctions is that Huawei has a Swedish company, has an investment in Sweden already. So it is present in the territory. It basically claims that its investment, its business generally is so severely affected by this decision of the Swedish telecom authority that there is a breach of the investment. But you see here that you need to have had an investment already in order to claim violations of, even if it's potential future impact on the business generally. I roughly see three elements that are important here: full protection security, fair and equitable treatment, and the rules on expropriation, perhaps a bit less. But you can, of course, easily claim, I think, if there are secondary sanctions that have an effect on the investment, that there might be a breach of the obligation for states to provide, and this is the most important aspect, fair and equitable treatment, which has, again, a very important aspect of non-discrimination included. You can also make the link, of course, to national treatment and most favored nation treatment, which are, again, the two non-discrimination standards. FET is fair and equitable treatment. It's composed of a list of subcategories: the obligation to act in good faith, the obligation to not take arbitrary measures, discriminatory measures, sort of sense of reasonableness in the adoption of legislation. So this might come into play. Again, it's not a given, it's not easy, in the sense that you would have to show that there is an arbitrary decision, that there is no proportionality in the decision taken compared to the objective you want to achieve, aside from the general fluidity of the whole concept of FET, which is really heavily influenced by arbitral practice. Expropriation also, of course, the obligation not to expropriate without any compensation, due process, etc. This is always a bit more difficult to establish, right? Indirect expropriation would result in a substantial deprivation of the use of the investment, which in some context might be argued. Huawei argues this, for instance, in Sweden, because its whole operation is basically, at least this claiming is becoming, to put it simply, relatively useless. So these, I'll not enter into details because then it's very hypothetical again. I think if there is an impact, these are the likely claims that might result from this. But again, we need to keep in mind that in terms of admission, establishment, expansion, it's really only non-discrimination in terms of national treatment, most favored nation treatment. If there is already an investment that is affected by the secondary sanction, which I think is not a given, precisely, again, because of the extraterritorial effect, you might envisage or you might imagine that claims on these grounds can be made. But again, it's not an easy claim to make, I think, precisely because of the extraterritorial effect. Has been a bit different for, I'll close with this, primary sanctions. There are also not necessarily a lot of cases. You have a couple of cases that relate to countermeasures, which I think are interesting. So I'll just give them to you because I think they might offer some interesting ideas also, but they are of course very different. Right? In the context, there's one interesting case, for example, corn products versus Mexico. It's a case under the NAFTA, which relates to a tax imposed on corn products that allegedly were made as a countermeasure. Right? The tribunal there took a relatively pragmatic approach, but which might have far-reaching consequences, which is basically that treaties like the NAFTA or investment treaties give direct rights to foreign investors, and those rights make them a third party to the dispute between two states. Hence, the rights are unaffected by the countermeasures, or the question whether an act is a countermeasure without even engaging in the discussion whether it was indeed a countermeasure. But it basically says those rights are not affected. It's a different dispute from the dispute between the two states. Now here also, of course, I think it might offer some interesting avenues in the context of secondary sanctions also, although we see, of course, more and more targeted sanctions that target individuals, companies, etc., which is very different from the traditional countermeasures reacting against state act by adopting state regulations. So they specifically target those rights of the foreign nationals individuals or companies. So that's one very different aspect which might have a role to play. At the same time, the general idea to say we have those rights and they're unaffected by everything that happens on the interstate level is also something that is interesting and might, I think, in the future, if cases become or increase in the context of secondary sanctions, might also be an important aspect to take into account, the extent to which you could actually consider that the sanctions regime is something that is sort of outside of the specific rights of the investors. I'm not entirely sure you can transpose it so easily, but I think there are some interesting ideas here. My time is up, so I'll leave it here. I think, again, on the arbitration proceedings, there's actually much to say on the responsibility of the institutions, the arbitrators, and especially the contractual aspect, not the treaty aspects. But I leave this for Maya Lester and Nicolas Angelis panel of later. So many thanks for your attention.
Thank you very much indeed, Erik, for walking us through the investment law perspective. We've covered quite some ground already this morning or afternoon for some of our online participants, of course, but we still, of course, have one further panelist. Last but not least, indeed, we have Geraldo Vidigal, who is an assistant professor at the Amsterdam Law School, where he coordinates the LLM in international trade and investment law. Geraldo is studied at Sao Paulo in Brazil, at Sorbonne, and he obtained his PhD at Cambridge University. And we're very happy, of course, Geraldo, to have you with us to discuss the security exception. The floor is yours.
Hello. Thank you very much, everyone. Those of you who were here in the room, have seen me updating my slides in response to Professor Stoll's very interesting presentation, where he already talked about some of the issues I'm going to cover, which is great. So I'm going to try to give you an idea of how the security exception interacts with the issue of sanctions in principle, and then we can think about secondary sanctions. And I'm going to look at both trade and investment law and where we are with this. I'll start by confirming that what Professor Stoll and Professor Brabandere have just said, which is that we have to think, first of all, of what obligation is being violated here. So often when you see people who are not in international economic law thinking about the exception, they go straight to the exception. But first you have to tell me, what is the obligation that is being violated here? And this is going to be key because many of these sanctions apply, as you know, not by the direct exercise of extraterritorial regulation, but via the, at least in principle, domestic exercise of regulation, which then has extraterritorial effects. So that said, where does the idea that just saying the word security very loudly before a tribunal or a panel is sufficient to exempt a state from having to address the issue because it's an international economic law panel? Wait. Is this the right? Yes. Sorry. This is the updated slides. So when we think of international economic law and the security exception, we can think of it three relations between the law and the rule in the exception, right? So we can think that, again, this idea that security is just outside the scope of economic agreements, and that's what the security exception, let's say, confirms. Second, we can think that the security measures are outside the jurisdiction of the adjudicators. So that's what the effect of the security exception is. And three, we can look at security exception as the substantive exception, which now we have become used to, but this was by no means clear. And when we look at what states argue before international adjudicators, be it WTO, investment arbitrations, even the ICJ, you often see the first two still happening, where they say where the states will be adamant that this is just outside the scope of this particular agreement, or that the court has no jurisdiction. We come. It is. Aha. Okay. No, does it work now? So apologies for the wrong one. So this slide just says what I just said. So and if you look at the ICJ in Nicaragua, it's the first case when this was looked at in some depth. So this was a treaty that had one of those friendship, commerce, and navigation treaties from the 50s that had a security exception. And so the court had to look at the argument that the security exception removed the dispute on these security measures from the scope of the treaty. And the court said, no, it doesn't remove it doesn't do that because it's a part of the treaty. So if we have competence to interrupt jurisdiction over the entire interpretation and application of the treaty, therefore we have jurisdiction over the interpretation and application of the exception. But the court also said that we can also look at Article 21 of the treaty and note that it doesn't use the same words as Article 21 of the GATT. So Article 21 of the GATT has the words which it considers. Therefore, by implication, it would seem that the GATT Article 21 would be outside the jurisdiction, let's say outside the jurisdiction of the panel, right? And so this was also used by a number of investment tribunals. They use the GATT as sort of foil to show that their exception is not subject, because here is, if you look at the GATT. So that we built over a few decades where there was no case actually before GATT panels on the security exception, this idea that somehow the words which it considers made the whole thing fall outside the jurisdiction of panels. But as Professor Stoll said, and I already showed you, this is what the exception looks like. It's not a jurisdictional exception. It doesn't say, panels do not have jurisdiction. It says nothing in this agreement shall be construed to prevent a contracting party from taking action which it considers necessary for the protection of its essential security interests. And then it has 3 subparagraphs. And so the first question then is, how do you interpret this? Now, the way we interpret this as international economic lawyers is by having recourse to our traditional means of interpreting the GATT Article 20, actually, which is this two-step legal analysis, which I find is always confusing to people who are not international economic lawyers, or often confusing, where first you find that there's a violation, and second, you find out whether the violation is justifiable. So, if you spend the first half of the panel report or appellate body report saying, well, here's a violation. And then after that, you say, well, now we're going to look at whether there's justification. And so you have often a finding that sounds contradictory, which is where there is a violation, but it doesn't count as let's say, it's not a true violation of the whole law as a whole, because it is justified normally under Article 20, which is the article of general exceptions. So, and what does Article 20 contain? We ask 2 questions. So it has 2 subparagraphs as it has a chapter. So the subparagraphs, I'm not going to put the whole text here because it's even longer than this. But it says, under the subparagraphs, we look at what is the objective that your measure is aiming at. So the subparagraphs allow members to pursue, to violate their agreements or their obligations, to pursue, with measures necessary to protect public morals, to protect the environment, to protect public health, and that kind of legitimate objective. And then we look at the chapeau, and the chapeau asks whether, under the chapeau, we ask whether the measure is applied in a non-discriminatory manner, or whether it's a disguised restriction on trade. Now, if we go back here to Article 21, it doesn't have a chapeau, right? It just says that nothing in the agreement shall be construed to do for any of these particular purposes. And so the way that we interpret this is to say, well, first of all, we have to find out whether the measure relates to any of the elements or circumstances in 1, 2, 3. And then we go to the chapeau, let's say the mini chapeau of Article 21, right? So and first of the I mean the steps, and that's something that was said, that the panel in Russia Trafficking Transit brought us to is say, well, first you have to show us that one of these 3 elements are in place. And so in relation to traffic in arms and to fissionable materials, there's some scope for saying that these elements, let's say that measures relating to traffic in arms or relating to fissionable materials are in a way, through the exception, excluded from the scope of the agreement, right? So because the relating to is it requires a very soft relationship, or a very, let's say, a mere relationship of cause and effect between the measure and the element being justified. But taking time of war or other emergency was always the tricky one, because then it requires a panel to say what is war or other emergency in international relations. Now, the way that the panel in Russia Trafficking Transit did this is a sort of sliced, instead of taking this, which it considers necessary, and using it as a big interpretative key for the entire provision, it sliced the provision into a number of different sub-legal tests where the party has to, essentially the party trying to justify the measure has to show that one of these circumstances are present. And so it has to show that there's war or other emergency, and then it has to show whether the protection of its essential security interests is at stake. Now, let me show you, I'll get back to this first. So before the WTO started looking into this, it's important to consider that investment tribunals looked at this. So we had the first wave of cases against Argentina, where the tribunals made a big mess out of the security exception. They essentially interpreted it it's not clear whether it's in the context of or more broadly in line with Article 25 of the ILC articles, which is the circumstance precluding no wrongfulness of necessity. And they got rightfully reversed, or at least condemned by the annulment committees for that. And so it wasn't, this was essentially a bit of, it feels to nowadays like a bit of primitive legal analysis. But back in the day, of course, it's hard to say, when you're the first one person has to have a go at this, it's more difficult than doing it 10 years later. But then we had 2 recent cases, Devas versus India and Deutsche Telekom versus India, where India reallocated a portion of its radio frequency and said that this was for the protection of security interests. And here, in the Mauritius case, the panel did the arbitral tribunal did something very interesting. So they said, well, there was no necessity argument. They said, well, it was the provision said, this is this agreement shall not prevent parties from taking measures for the protection of their security interests. So there was no necessity requirement there. So what did the tribunal do? They say, well, the respondent has to demonstrate to establish that the measure in question is related to its essential security interests. And more importantly, it said it cannot be any security interest, but it has to be an essential one. So here's a subset of security interests that are essential security interests. And then the tribunal decided by majority, because there was one dissent, that a reasonable allocation of the spectrum directed to the protection of the respondent's essential security interests would not exceed 60% of the S-band spectrum allocated to the claimants, the remaining 40% being allocated for other public interest purposes and being subject to the expropriation conditions. So the tribunal essentially decided to say, well, here's your whole measure, 60% of it, we agree, that's essential security, and 40%, it's just general public interest. And the subsequent tribunal, which concerned more or less essentially the same measure, but against a different telecom company, said the same thing. So what they wanted to know is whether the measure was principally targeted, so it was a different legal test, instead of saying, okay, let's say slice the measure into percentages, they say we're going to look at whether the measure itself was principally targeted to protect the essential security interests at stake, and was objectively required, because here there was a necessity test, in order to achieve that protection. And so the tribunal here also said that the spectrum in case was not reserved for essential security interests. So that while it was true that the measure refers to the needs of self-defense, paramilitary forces, rails, and other public utility services, as well as it also referred to as well as for societal needs. And because of this societal needs, public utility services, railways, the tribunal said, well, this is not a measure to protect. Overall, this is not a measure necessary to protect your essential security interests. And also, we note that it took 4 years of discussion among the government officials to decide how to reallocate the measures. Therefore, we cannot say retrospectively that because some of this spectrum was reallocated to the military, given that it was, let's say, up for grabs for 4 years, this was not retrospectively a measure to protect security interests. So yeah, so here's Russia trafficking transit. These are the sort of slicing and dicing measures that the panel looked into. The slicing and dicing procedure that the panel created in order to review the measures. But yeah, so I'm gonna skip over this one because Professor Stoll already spoke about this. But here the important part for us is that the panel did find that this was Russian restrictions. These were Russian restrictions on transit of goods to Ukraine and from Ukraine. And the panel said, well, this is plausibly an international emergency. And here I think it's important for you to note that there's no assessment of responsibility for the situation. So it can well be that it was, let's say, in this case, Russia that created itself the emergency that it's now into. But secondly, and then more importantly, within the scope of this emergency, these measures were plausibly related to protection of Russian essential security interests within this emergency. But in the subsequent case, Saudi Arabia IP rights, that's a case from last year, the panel did not find that the entirety of the measure was to protect Saudi Arabia's essential security interests. Here, what the measure was very interesting. There's a Be-In, which is a Qatari, apparently, TV network that shows football, and it's very popular in the whole of the region. And what happened is, more or less at the time that Qatar and Saudi Arabia had a fallout, then this Be-In, the signal stopped working in Saudi Arabia, and something called Be-Out-Q started transmitting a pirate signal with the same content, and Saudi Arabia did nothing to do it. And then what Qatar went to the WTO and said, well, these are measures, these are a violation of intellectual property rights of Qatar. And then the panel looked into all the measures that Saudi Arabia was taking and found that many of them, including not allowing Qatari officials to complain before Saudi Arabian tribunals, not allowing lots of things against Qataris, were, let's say, reasonably connected to the emergency between these two countries. However, it also found that by failing to prosecute these pirates, that Qatar was not only violating Saudi Arabia's rights, but also violating the rights of third parties, including the parties from the EU and Brazil. So it's very interesting that although this was a Qatar versus Saudi Arabia case, let's say the winning argument came from the EU and Brazil as third parties, because they said, well, our rights, our IP rights, the IP rights of our nationals are also being violated. And so this was sufficient for the tribunal to say, well, this non-prosecution is not covered by the security exception. Final case, I think with this is over. So yeah, so these are the tests, but I think Professor Stoll spoke about this. So you have to define what emergency you are in. You have to articulate your security interests, and there has to be a plausible relationship between the measures and security interests. Now, let me just finalize with one case that is interesting, which is about sanctions more properly, which is a case that the US against China. So this was about the US tariffs on Chinese goods that was adjudicated this year, actually a couple months ago. And China came to the WTO and said, you know, what are all of these WTO inconsistent tariffs? Now here, I would assume that the US could not credibly claim that it has a permanent emergency in international relations. Because of course, an emergency has to have certain definition of a heightened state of affairs. That's I think how the panel versus Trafficking was interpreted. And here, you couldn't say that. So what the US said was that this was required to protect public morals. That China was violating US IP, and that IP was a very important moral issue for the US. And therefore, they adopted the restrictive measures on all of these goods from China in order to, let's say, force China to change its violation of intellectual property rights. And here, what the panel did was it said, well, and so therefore, this was an Article 20, not an Article 21 defense, a public morals defense. And then the panel looked at this and said, well, this is interesting, and maybe we cannot say whether protection of IP rights is or is not a public morals issue in the US. Let's say it is. Can we say that this measure is necessary to protect public morals? And then they did this question of what is the connection between the measures you're taking and the public morals you're claiming to be protecting. And say, well, we cannot reconcile Article 20, and presumably they would have said Article 21 as well, with a situation where WTO members would be allowed to restrict any trade from any WTO member with the mere invocation of what might, in an abstract sense, be considered a valid policy objective within the meaning of Article 20. The scope of the restrictive measures require that there is an objective relationship between the measures and the objective. So there has to be a nexus, and in this case, the US was not able to show that there was a nexus between prohibiting the importation of toys or steel and the protection of intellectual property rights. So I think we have a good, let's say, a good, at least if not necessarily an answer in terms of WTO law or investment law. We have some parameters already to start thinking about how this would apply to secondary sanctions. Thank you.
Thank you very much, Geraldo, for your presentation that also nicely complemented the previous one by Professor Stoll. We still have some good 30 minutes left, I think, for questions from the audience and for further debate amongst the panelists. And of course, the floor is open both to our online participants as well as those present here at Ghent. I already see two hands being raised, Gustavo and Suze. Gustavo, I think you were the first, so let's start off with you.
Okay, can you hear me? Yes. So, well, thanks to everyone. It has been like a really interesting and very wide panel on the topics of international economic law. I will just go very quickly with some questions. I will start with Eric de Brabandere on international investment law. What happened with enforcement of awards that can be related with sanctions? I was thinking especially on the case of non-ICSID awards that they have to be executed through the New York Convention, and then you have this public policy exception. Is that something to take into account for enforceability, and what will also happen with ICSID awards? That's the question for him on terms of international investment law. Going to international commercial law, I have a question that maybe Tobias or Gerardo, I don't know which one could give me an answer, but is related to the standard of proof, especially taking into account the Russia transit. Because if the Article 21 is not self-judging and you have an objective criteria, the panel used some security, United Nations Security Council resolutions to establish that there was an objective criteria for an emergency. Is that some kind of standard of proof that will have to be held? So only when a conflict will arrive to some kind of provisions that are treated like on the Security Council, that is the level of proof of what do you think should be the appropriate proof of these objective criteria of Article 21, especially considering this interesting resolution on the Russian transit case. And on finally to Ana Maria on the side of the international financial law. So if I understood correctly, we are basically stuck with this executive board decision of 144. So my question is, what will be the road ahead? Because obviously there will not be any political will to probably modify this resolution or this decision. Is there a way to interpret this decision in light of United Nations principles? And I was thinking on Felipe's presentation yesterday about the principle of non-intervention. Can any of the principles from the chart be used to interpret it, since it will probably be difficult to modify? So what are your vision on the road ahead in this area? So thanks again, and also thanks to Tom for the conference.
Okay, excellent. Let us perhaps first collect a round of questions. Susan.
Coming. Hi. Just a quick question to Ana Maria, or maybe two questions. One is, did I understand you correctly that your position is that monetary sovereignty would not extend to restricting those payments we talked about yesterday that pass through, for instance, the United States, because you say the nexus is not strong enough, but you did make the exception saying, well, if this use is facilitated by a US financial institution, then the situation is different. If that is the case, my answer to that would be, you cannot use the US financial system without a US financial institution. So I think the exception becomes actually the norm. The other thing, I think your argument, and that's interesting if also frustrating, you say that external monetary sovereignty can restrict payments, but restriction would be still sort of restricted more, or these restrictions would not be possible by the IMF articles in principle. But then your analysis leads to, if I look at it exactly, at the moment, there is no venue there. Is that your, did I understand you correctly? That's just a question whether I really understood your analysis. Thank you.
Okay, on that note, I would perhaps pass the floor to Ana Maria Viterbo herself, perhaps not to answer the questions previously posed, so do resist the temptation for a minute, but to pose a question of your own, if I understand correctly.
Yes, thank you. I have a question related to the ICJ case pending between Iran and the United States on the 1955 Treaty of Amity. The court adopted an order October 2018 affirming prima facie jurisdiction and rejecting the preliminary objections raised by the United States on the fact that the Treaty of Amity does not cover extraterritorial sanctions. Interestingly, the court never used the word sanctions. It always cited sanction between commas, citing the United States. It refers to measures, but still, it seems that at this point there is still something to be debated within at the merits level. And Judge Ad-hoc Montaz, in its declarations added to the order, refer to secondary boycott measures, looking into the fact that they are unlawful under point of view of international law, for looking at the principle of non-intervention, looking at WTO law, and then it also open up discussion about Article 20, the security exception in the Treaty of Amity. So could Eric and Gerardo further elaborate or maybe speculate on what will happen next?
Okay, before starting to speculate, one last question from the online audience. Amir Hossein, Malik Madami, the floor is yours.
Hello, good morning. Can you hear me? Yeah. Thanks for the discussions. I have two questions, one relating to the WTO law and the second one relating to the international investment law. My first question is that, is there any use in the interpretation of Article 21 of Ghent agreement and what Professor Vidigal said about the interpretation of Article 20, or are they completely separate, or is there any ground that we can use the interpretations made from Article 20 in interpreting the measures under Article 21 or not? And the second question is relating to international investment law. And the question is that whether the cases brought because of secondary sanctions or its effects, should it be, can it only be against the sanctioning state, or it can be against a state who is implementing the sanctions made by another state? For example, state A made sanctions against state C, and state B is implementing the sanctions made against state C. Are those also covered by the possible actions that can be brought against the secondary sanctions? Thank you.
Okay, thank you. Let us turn back to our panelists, and maybe we can follow the same order we did for the presentations as such. Anna-Maria.
Thank you, Dante. Thank you, Susan and Gustavo, for your questions, and they will allow me to clarify some points. So first, internal and external exercise of monetary sovereignty. Internal, the fact is that when a state decides how to decide its currency or whether it has legal tender, this kind of regulation should be recognized abroad by everyone. External monetary sovereignty means that refers instead to the adoption of exchange restriction and capital controls, but these does not equate with a parallel obligation on other states to recognize, enforce, and implement such regulations. And this is the starting point. Then, for the point of view of the IMF, the same IMF has always affirmed that exchange restrictions should be, in principle, as we mentioned, avoided to the greatest possible extent. But in its practice, it allowed a huge number of security restrictions to be adopted without even discussing them. And if you look at the annual report on exchange restrictions, the ROR, that I've mentioned there was a reference in my slides, the number of exchange measures adopted by the United States under the decision 144 is huge. There is a reference to all primary and secondary sanctions they have adopted since back in the 50s. And no discussion basically were held at the executive board, maybe only at the very beginning about Iran and Libya in the 80s, but after that, they smoothly went through the system. If you look at the exchange measures notified by Germany, for example, you will find also a number of them, but other countries notify measures that are more related, more of a multilateral nature, not of a unilateral nature. The question of the IMF as a UN specialized agency and the duty, the obligation following from that status, following on the UN Charter. The point is that when the relationship agreement between the UN and the IMF was signed back soon after the Bretton Woods conference, the UN wanted the IMF to be more, let's say, in line with UN obligation. But the fund managed to obtain a huge independence, so that the fund has always maintained that it can continue providing, for example, financial assistance to countries that are under sanctions adopted by the UN through Security Council resolutions. And this can extend to questions about sanctions imposed not only multilaterally, but also but in a way which like unilateral sanctions that are not covered by UN Security Council resolution.
Okay, thank you, Peter Tobias.
Thank you very much. First of all, Gustavo, thank you for asking for the connections to the system for international security as represented in the United Nations and chiefly with the United Nations Security Council. There's a link to that in Article 21, litera C, where members of the GATT at the time and now the WTO are given the authority to take any action in pursuance of their obligations under the United Nations Charter for the Maintenance of International Peace and Security. And one of those fascinating clauses that we saw early on when the post-war international system was developed, people right away took into account potential linkages between the different systems, and so they were inserting into the GATT agreement language referring back to chiefly chapters 6 and 7 of the United Nations Charter. But I would say yes, in cases where the United Nations Security Council has discussed and even has taken decisions on a certain situation, we could take this as a good proof for war or other emergency in international relations back in Article 21, litera B of the GATT agreement. But I would underline that, of course, this does not right away exclude other situations which remain outside the UN and particularly the Security Council to be qualified as those situations of war or other emergency in international relations as well. You know, because of the many kind of limitations within the UN peace and security system, it cannot be concluded nowadays that we can directly link in a way Article 21 of the GATT agreement to that system. And also we have to be reminded that litera C is explicitly creating this link, and the fact that we are talking about war and international emergencies also in litera B would advise us to see that there is a difference. So yes, if there is action of the Security Council, we can take it as a proof, but if not, that does not foreclose that we find an emergency in international relations under litera B on other grounds. Otherwise, I'm particularly happy with all the discussions, and I think it's on Geraldo to discuss the question of the interrelationship between Article 20 and Article 21 and the many kind of conclusions about the interface between the two and commonalities in wording and interpretation. On the other hand, of course, in Article 21, we have this mentioning of consideration of the member at hand, which is different from Article 20. Thank you very much.
Okay, we again move over to the two on-campus panelists. Erik, you can use the microphone and we can see them.
I will leave most of the discussion of this to the next panel, but I do think indeed that the most important consequences of sanctions is not necessarily on the dispute itself, but on the arbitration proceedings that follow from it and how to indeed enforce it. I think here also, most importantly, you will have questions that arise in contract claims more than treaty claims. There have been several cases that have already discussed this, but without really preempting what will be said in the next panel. I think for ICSID arbitrations, the problem is a bit less important because, of course, there is an internal annulment proceedings and, as a consequence, an automatic enforcement in all ICSID member states as if the award was a decision of a domestic court. In non-ICSID arbitrations, it's a bit more complicated. And you have had several cases that were also appealed and decided by domestic courts. One of them recently in 2020, I think, if I remember, Motsaf versus International Military Services, an interesting case in the UK. That very complex case, but basically relates to the question of whether money that had been put on an escrow account and that had generated interests, whether those interests could actually be paid. Notably because in the meantime you had sanctions from the EU, and the UK High Court was upheld afterwards, considered that you cannot pay the interests on the money that was put in an escrow account because this would be in violation of the EU regulations. So that's an important case and basically reflects, I think, general, it's a well-argued case also, so I think it can reflect, but it's very sanction regime specific. Right? This was based also on specific EU regulation that set out the prohibition for claims to be paid, etc., etc. So the enforceability is an issue. It's really, it's a big problem. Also in light of the blocking statute, the guidelines from the European Commission, if I remember well, say very clearly that you cannot give any effect to decisions that are in violation of the blocking statute. This would not necessarily mean that you cannot arbitrate such disputes, but it may have consequence on giving effect, that is, enforcing these in the EU. Then on Anna Maria's question on the ICJ case, well, I've learned really one important lesson is to never speculate on ICJ decisions. It's very difficult. I think the decision on jurisdiction is sound on merits. I think the question will turn around and I really pass the floor to Gerald, who might not like it, but the question will not necessarily be whether there's a violation. I think this will probably be easily established. The question will be whether there's an exception that is justified under the Treaty of Amity of 1955. So I think I will leave it to Geraldo to answer this one. And then there's Amir, who I know because he's a former student, but I forgot his question now. Otherwise, we pass the floor to Geraldo and then we'll see if we have time afterwards.
Sure. Thank you, Ian, for giving me the question that you explicitly said was should not be speculated about. But let me speculate about it. So let me start by talking about the question about if you can use Article 20 to interpret Article 21. WTO litigators are always a bit fussy with this, and it's a lesson I've learned. You know, you shouldn't transpose jurisprudence or considerations regarding Article X to Article Y, even though they often do. So I think the way that Article 20 and Article 21 interact, first of all, they are built the same way, so nothing in this agreement shall be construed to prevent. And then the difference here is that Article 20 has a chapeau, so it basically says under Article 20, your measure has to be non-discriminatory and not a disguised restriction on international trade. And the second point is that Article 20 has this necessary / relating to distinction. So if a legitimate objective is protected, if any measure that relates to the objective is under the exception, then this means that there's a very weak nexus that you need to find, or you need a nexus, but any measure that has a causal nexus or a nexus, a connection to that contribute to the objective is exempted, right? So it doesn't need to be necessary measure. It doesn't need to be better or more effective than other measures. Whereas if a measure has to be necessary, then it has to be, and of course necessary has a very specific, there's a whole scholars whole, there are whole books written on the meaning of the set of the word necessary. But it essentially doesn't mean that it has to be indispensable, right? That's one of the things that the first Arbitrations tribunals got wrong. They said, well, it's not necessary because we can envisage other ways that Argentina could have dealt with this crisis. But that's not, necessary doesn't mean indispensable. Otherwise, barely anything would be necessary, right? Because you can always think of, there are always, or almost always ways that you could do otherwise that would be more costly or more risky or create or less effective. So what necessary means is that there's no measure that is as effective as the measure you chose for the protection of your desired objective, and that is less restrictive to trade, right? So it doesn't matter if a measure is much more restrictive to trade, but there is no alternative measure that gives you the same level of protection of your objective, then your measure is still necessary. Now, what Article 21 includes, the security exception has, is this, which it considers necessary. And here it was a bit the trick, and you know, I always think of this as you know, Jean-Jacques Sab was the chair of this panel, and I always think of, you know, admire his and the other panelists, of course, legal minds, because when everyone who read Article 21 until then, or almost everyone, had thought, oh, you know, if it says which it considers necessary, it means that the government has to, you know, it has complete control over what its essential security interests are and what measures are required for that. But actually, the way the panel interprets is that, well, which it considers necessary is a way to say relating to. So the measure still has to be demonstrably for the protection of your essential security interests. And your essential security interests are just a subset of your security interests. So you have to show what these essential security interests are, you know, and they cannot be just any security interests. And second, there has to be a connection. So the idea is that which it considers then refers only to the word necessary, right? And then the further protection becomes an independent source of legal test. Now, why is I'm saying this? Because I just looked up again the decision of the ICJ, and the treaty is interesting because the first, so it covers two issues here, and I'm sort of going to stop quickly because I'm somewhere out of time. But I'm going to speculate very quickly then. So what the treaty has, it's exempt from the treaty or from it creates exceptions for measures relating to nuclear materials and fissionable materials, etc., and that are necessary for the protection of the security interests. So my suspicion is that the measures, in this case, the sanctions themselves, do they relate to this? They don't relate directly to the nuclear materials, right? So maybe they relate indirectly, but that would clearly seem to cover measures that relate to the materials themselves, not that relate to your interest in general of preventing the spread of nuclear materials. And then I would rule out this provision. But the second one, whether this is a measure necessary to protect U.S. security interests, I think it's tricky because I would say that under the Russia trafficking transit, for example, paradigm, this is very much, I would say that, I mean, I would assume that the nuclear security is an essential, like preventing nuclear proliferation is an essential security interest of the United States. So then the question will become whether these measures were necessary in the sense that there wouldn't be less violating measures or measures producing a weaker level, a weaker degree of violation that would attain the same objective as the sanctions do. while being less restrictive on Iran and its rights. So that will stop here. Thank you.
Okay, thank you. If everybody agrees, I would suggest we have a very quick second round of questions. Maybe first look at people within the audience. I see a few raising their hands. So if you have a question, please step forward towards the mic to pose your questions so people can both hear in the venue and also at home. Philip, do you want to go first? And please keep your questions brief and inevitably the answers will have to be rather succinct as well.
So I have two brief questions for Professor de Brabandere. When you mentioned these standards that are most relevant, you said FPS, LET, expropriation, national treatment, MFN. One thing which I wonder, I know in the 1970s and 1980s, the European community for a very long time also negotiated or tried to negotiate a plurilateral treaty with the League of Arab States in the Euro-Arab investment talks. One of the key reasons why it failed and one of the key asks by the Arab states you can see in the archive is that they also asked the inclusion of a clause on asset freezes. And I wonder if you know of any BIT practice, potentially more between Arab states, where you actually also have a clause which prohibits asset freezes. That's my first question. And then the second one, you briefly mentioned the Huawei versus Sweden case, and that Huawei was making a claim under the expropriation standard. I'm wondering, do they do that because it's a first generation Chinese BIT, which only allows to recourse to exits for cases of expropriation, or is there a specific other reason why they don't use LET, which would seem like the more logical way to go? Thank you.
One more question coming up.
Thank you very much, and thank you to all the panelists for the very rich presentations. I have two quick questions. The first one is for Professor Viterbo. You mentioned that you showed that capital movement restrictions and exchange restrictions for security reasons are never objected basically by the board when notified by the IMF board. So I wondered if you could give your opinion on whether this non-objection does equate to request or a specific approval by the fund, because of course this raises questions for ex-ante coordination clause included in other agreements in international economic law, such as FCN treaties, but also WTO law with Article 11.2 of the GATS agreement. And another question for Professor de Brabandere. Maybe I missed it, but could you also elaborate a little bit on the denial of benefit clause, and if you think it will be applicable in the context of secondary sanctions? Thank you very much.
Thank you for the questions. And if I can use my position to ask one final question, perhaps for Professor Stoll. You talked about the potential violations of the WTO agreements, including the GATS. And the question is whether this triangular dimension of secondary sanctions poses a problem in that respect. And for instance, when you think of import and export restrictions and the provisions related to under the GATS, well, what about the following example? A denial of access types of secondary sanction, where, for instance, a Belgian company that wishes to ship automotive equipment to Iran is threatened with a loss of access to the United States markets. So this is a very triangular issue. And can you see there's an import restriction in the sense of the GATS as such? Any thoughts on that would be much appreciated. But let's perhaps start with Erik, if you want.
Yeah, thanks. Very, very good questions. On the Huawei Sweden case, expropriation is one of the claims. So it basically throws everything at it. FET, expropriation, protection, security, it's basically everything. This is in a notice of arbitration, which is really 2.5 pages. So, I mean, we'll have to wait and see how it develops. But it's basically everything, including expropriation. So yeah, we'll have to wait and see. On the asset freeze, there is, I tried to look it up. I know there are some treaties which have this, but I have to look, I completely forgot which ones. I can look it up and then pass it on to you. I read it yesterday when preparing also, I forgot. But there are treaties, recent treaties, that have included rules on asset freezes, specifically, I think, as a reaction against these sanctions. And then finally, on denial of benefits, yes, this is an important aspect also. I didn't cover it for lack of time. But denial of benefits, of course, allows the state to deny the benefits of a treaty for the who, on certain conditions from states that they have no diplomatic relations with, or that are, in the end, investments owned by investors of a third state to which there is no relation. So this is also one of the aspects which definitely can come into play. The question then will also be, do you need to, in advance, deny the benefits, or can you do it ad hoc when the claim has been made, which is one of the tricky aspects of the denial of benefits. But I agree, this is one of the aspects also which definitely will come into play. So good that you raise it.
Okay, Professor Viterbo, you want to respond?
Nice question. There were a lot of debates within the executive board at a certain point during the 80s about the fact that the non-objection related to security restrictions made security restriction to fall squarely within the scope of protection granted by Article 8, Section 2B. So, and in the end, that interpretation was accepted. So they are covered by Article 8, Section 2B. So if we consider security exceptions to be consistent with the IMF articles, then they will also be covered by, for instance, GATT Article 15 on exchange arrangements, so the coordination clause you mentioned. This is my understanding.
Professor Stoll, you have the floor for the last question, I believe.
Thank you very much, Tom. I think you mean your last question, which was indeed a very nice one. The triangle. So what about if the US puts pressure on Belgium to make Belgian businesses to abstain from trading with Iran? And then the question would be, under primary rules and commitments under the WTO, would that be already a violation on the side of the US? And I think the more classical argument in this regard would be that rules and commitments under the WTO apply in regard to measures to in relation to your own market. So if the US would stop, in a way, if the US would stop access to the Iranian market vis-a-vis Belgium, then the US would not violate, I'm afraid, primary rules and commitments under the WTO itself. It is very difficult to see, but when we wrote the report for the European Parliament on sanctions, we have been sitting together and trying to figure out all the intricacies. And it turns out what I said in the beginning of my presentation, the WTO is far from representing something like a Magna Carta for international trade altogether, but indeed it comes down to a bundle of very specific kinds of rules and obligations which relate to certain trade relations and trade transactions. And I would say the rules basically only apply in view of measures taken for the own market, unfortunately. I would, of course, love that it would be otherwise, but I'm always frustrated to see that the WTO comes in here in so only limited places, which are, by the way, also very difficult to see in a systematic perspective. It's simply not built for this kind of a threat to international liberal trade, I'm afraid. Thank you.
Okay, thank you very much. And I think on this note, we can conclude our first panel for the second day of the conference. We've had a very rich discussion in my view. I hope you'll agree. So please join me in a round of applause.